Managing Staff Protective Leave Part 1. Welcome to this Fáilte Ireland video series designed to support tourism and hospitality businesses in meeting your employer obligations. My name is Dominica O'Sullivan. I am a human resources consultant with Action HR Services. Over 2 videos in this series, I will discuss the various types of protective leave that employees may be entitled to avail of. We will consider an overview of the relevant legislation, an overview of employee entitlements, employer responsibilities, risks associated with non-compliance, upcoming legislative changes, and we will finish by considering some top tips. In another video in this series, we discuss protective leave relating to pregnancy and parenting. In this video, we will look at the other types of protective leave, specifically carers leave and force majeure leave, as well as the upcoming legislation, the Work-Life Balance and Miscellaneous Provisions Bill. Protective leave can also be referred to as protected leave. The types of leave that are specified as protective or protected include carers leave and force majeure leave, as well as all types of leave relating to parents and parenting. The term protective leave means that employees on these specific types of leave, such as maternity, paternity, or carers leave, are entitled to be treated as though they are not absent from work. This also means that the employee's absence while they are on any type of protective leave will have no impact on their rights and entitlements in relation to their employment, for instance, their entitlements to accrue annual leave. Essentially, protective leave relates to types of leave where people's jobs and entitlements are protected overall. Employees availing of any type of protective leave also have the right to return to the role they held immediately before they started their leave, and when they returned to the role, this must be under terms and conditions that are no less favourable than when they were receiving prior. In addition to this, if the terms and conditions improve in the organisation while an employee was on any type of protective leave, he or she is entitled to avail of these improved terms and conditions on return. This area of employment law has undergone significant change in recent years and is set to undergo further expansion in the near future. The types of leave that are considered protective leave are carers leave, force majeure leave, maternity leave, health and safety leave, paternity leave, adoptive leave, parental leave, and parents' leave. If an employee has worked for the same employer, even in different roles, for a minimum of 12 months without a break from employment, he or she has a statutory entitlement to carers leave if needed. This leave is taken by an employee if they need to provide full-time care for a relative or a friend. To apply for carers leave, the employee must first complete an application form for carers benefit, which is available from the Department of Social Protection. As their employer, you will also be required to part complete the form and confirm your employee's employment details. In addition, the GP of the person requiring the care will also complete a section of the form. The form is then submitted by the employee to the Department of Social Protection, and a deciding officer then determines whether the person whom the leave is applied for is in need of the care. Once that application is processed and approved by the deciding officer, the employee must give you, their employer, at least 6 weeks of notice of their intention to take carers leave. This should be done in writing. In exceptional or emergency circumstances where 6 weeks' notice cannot be given, the employee must give notice as soon as possible. If the leave is granted, both you and the employee should sign a document confirming this agreement. This should take place no later than 2 weeks before the employee intends to take carers leave. Typically, the employee can apply to take a minimum of 13 weeks. The maximum entitlement to carers leave is 104 weeks. In relation to the format of the leave, a continuous period of 104 weeks can be taken, or shorter periods adding up to 104 weeks can be taken. If shorter periods of leave are taken, there must be a gap of at least 6 weeks between them. There is no legal requirement to pay for this leave. However, your employee can apply for carers benefits from the Department of Social Protection, and if he or she does not have enough PRSI contributions, an application for carers allowance can be submitted instead to the Department of Social Protection. The employee has no entitlement to pension contributions from an employer while they are on carers leave. During carers leave, the entitlement to earn annual leave and receive public holiday entitlement continues for 13 weeks from the start of the leave. However, after that, there is no entitlement to accrue either until the employee returns to work. If an employee's carers leave has been terminated, the employee cannot commence another period of carers leave to care for a different person until a 6-month period has elapsed since the termination of the previous period of carers leave. Records in respect of carers leave should be retained for a period of 8 years. Force majeure leave entitles employees to deal with emergencies resulting from the injury or illness of a family member and where an immediate presence of an employee is essential. For example, force majeure leave would be required if an employee's child becomes ill at school or the presence of the next of kin is required due to a medical emergency. Force majeure leave is an entitlement to paid time off up to a maximum of 3 days in any period of 12 consecutive months or 5 days in any period of consecutive 36 months. The family members this leave can be availed of for are child or adoptive child of the employee, the spouse of the employee, a person with whom the employee is living as husband or wife, a person to whom the employee is acting as a parent, for example, if the employee has been assigned as a guardian to a child, a brother or sister of the employee, a parent or grandparent of the employee, and a person in a relationship of domestic dependency. The employee must, as soon as it is practically possible, and no later than on his or her return to work, submit an application for leave to ensure that they were actually entitled to it. There is an example of such a form in supporting resources with this video. The entitlement to accrue annual leave and receive public holiday entitlement while on force majeure leave remains unaffected. The employer must keep records of all force majeure leave for a period of 8 years. We will now briefly discuss the upcoming legislation, the Work-Life Balance and Miscellaneous Provisions Bill 2022. When enacted, this will introduce 5 days of unpaid leave per year per employee, where the employee is required to provide personal care or support to family members of loved ones for serious medical reasons. The employee will not be able to take this leave for a period of less than 1 day, and no prior notice will be required to be given to the employer. The employer will, however, be able to ask for evidence of the relationship or certification of medical illness. The legislation is also set to provide for the right of a transgender male who has obtained gender recognition certificate and becomes pregnant to fall within the scope of the Maternity Protection Act. Finally, the legislation is set to introduce paid leave for victims of domestic violence. Once enacted, those who are suffering or at risk of domestic violence will be entitled to 5 days of paid leave per year. To summarize the employer's responsibilities in relation to protective leave, it is recommended that the employer and those acting as managers in businesses become proficient in relevant employees' entitlements and implement appropriate policies in respect of the various types of leave. At a minimum, such a policy could simply say that the leave will be granted in line with the provisions of specific legislation. Employers should also follow the specific requirements in relation to documenting the various types of leave and record keeping. As I said previously, some types of protective leave do not have specific requirements relating to record keeping. In these cases, I advise that you follow the recommendations related to record keeping, which I have mentioned throughout this video. You may have certain payroll or HR management systems in place to help you record this type of leave for your employees. If not, you can simply maintain physical records on employees' file. All employers should ensure that the relevant protective leave is granted in line with relevant legislation and company policies, and that the employer assists the employees in completing any documentation required by the Department of Social Protection, and that the relevant payments are processed for employees if applicable. Should you fail to comply with the relevant staff leave legislation or company policies or be inconsistent in how the leave is granted, this could lead to low staff morale, employee relations issues, and even Workplace Relations Commission inspections and cases. It is for that reason that employers should ensure they all meet the responsibilities with respect to staff leave. Creating policies around each type of protective leave will guide an employer in standardizing procedures so that each employee is treated fairly. Good and consistent leave policies will ensure a business runs smoothly and reduces the chance of being the subject of WRC investigations and cases that may negatively affect an employer's brand and appeal as a prospective good practice employer. There are also many other benefits, including increased employee satisfaction and retention, while it's also complying with employment law. Further information and guidance on how to fulfill your employer obligations is available in the other video resources in this suite.